Good afternoon, teacher. It is a pleasure to be presenting our final project about arbitration in Peru. The members of our team include Mari Carmen Jaxa, Kelly Ortiz, Ivana Lopez, and who's talking, Natalie Gonzalez, and Deborah McDonald. First, I'm going to start with the introduction. When we hear about disputes and conflicts, our minds often jump to courtrooms and legal battles, but actually there's another way to resolve conflicts, such as the arbitration, which is a conflict resolution method involving a third-party arbitrator. This method has a rich history spanning cultures and civilizations. Originating from ancient Mesopotamia and Greece, it gained prominence in commercial transactions as trade expanded. The medieval period saw its adoption by European guild and maritime communities. The 19th century formalized arbitration, leading to institutions like the International Chamber of Commerce in 1919 and post-war II, the New York Convention of 1958 facilitated global arbitration acceptance, and today arbitration is preferred for various conflicts globally, including commercial, investment, and sports disputes. In Peru, arbitration traces back to the colonial era, gaining institutional significance with the Civil Code of 1984 and a milestone in 1996 with Law 26572. Then, Legislative Decree 1071 in 2008 consolidated arbitration principles, contributing to its acceptance. Now, arbitration offers various classes tailored to the preferences and needs of the involved parties. These distinct classes include first the institutional arbitration, and in this case, parties opt for this type when they agree to conduct arbitration under the procedural rules of a specific arbitration center, such as the Lima Chamber of Commerce's Arbitration Center or the AmCham Peru International Arbitration Center. These centers manage the arbitral process, providing administrative and logistical support. A roster of arbitrators is maintained, and parties can choose individuals to resolve their dispute. Notably, arbitration centers facilitate the process but do not decide on the dispute, and fee schedules are established to determine costs and in advance. Then we have ad hoc arbitration, in which parties do not submit to any arbitral institution. Instead, they define the rules of arbitration, or in the absence of such rules, follow provisions of the arbitration law. The administrative and logistical aspects are handled directly by arbitrators appointed by the parties, who in turn may appoint an arbitral secretary. Arbitrators themselves set fees considering the case's complexity and amount in dispute, of course. Then we have the law arbitration that involves a tribunal that bases its decisions on the laws and regulations applicable to the contract in questions. For instance, commercial contracts may refer to the Commercial Code and the Civil Code. In this scenario, arbitrators are typically legal professionals resolving conflicts within a defined legal framework. Finally, we have the conscience arbitration, and this type of arbitration doesn't rely on specific laws or regulations. Instead, the arbitral tribunal determines what is just and equitable based on principles and due process. For example, in a real estate lease dispute, the tribunal considers the facts and parties' actions to find a fair solution without necessarily adhering to specific norms. And this type of arbitration is rooted in the arbitrator's knowledge and honest judgment, making it distinct from rule-based resolutions. Now, in Peru, the legal framework governing arbitration is rooted in both constitutional provisions and specific legislative acts. First, we have obviously the Constitution, and in this case, the Peruvian Constitution in Article 139, Paragraph 1, acknowledged arbitration as a mechanism for private justice, and it emphasized that no independent jurisdiction except a military and arbitrations can be established. This highlights the constitutional recognition of arbitration as a means to resolve or prevent conflicts through the decision of a third party. Then we have the Civil Code, and historical antecedents of the arbitration agreement are found in the Civil Code of 1984, specifically in Article 1906 and following. The compromissory clause, considered a preparatory contract by some, obligated parties to enter into arbitration if a dispute arose. The legislative change aimed to address challenges where the compliant party faced difficulties obtaining the arbitration commitment from the other party, thus hindering the speed characteristic of arbitration. Finally, the evolution of arbitration law in Peru involves several key legislative changes. First, we have the Decree Law number 25/935 that recognized arbitration but had limited regulation within the Civil Code. Then we have the Law number 26/572 that's like the general arbitration law of 1996 that provide a comprehensive regulatory framework for arbitration. Then we have the Legislative Decree 1071 of 2008 that include further modifications and consolidations of arbitration principles. And finally, we have the Urgency Decree number 20 of 2020 that modify Legislative Decree 1071 in some articles, but only those related to arbitration with the state. And it is worth mentioning that the Article 13 of the arbitration law is one of the most important regulatory provisions as it regulates the arbitrations agreement, and these include essential elements such as willingness to submit to arbitration and also the determination of the relationship.
Continue with this topic. As we have seen, arbitration is a means of resolving disputes. It has only one instance, being a singular process without enforcement power. Therefore, it relies on the judiciary to enforce the awards. Furthermore, you can dispute the annulation of the award if you have valid reasons, based on the specific grounds listed in Article 63 of Legislative Decree 1071. Judges won't get into the details of the disagreement, but will only look at the procedural aspects. Some confusion persists among judges when trying to explain issues such as lack of motivation within an arbitral award. It was evidenced in the case of D&M Consortium against the Ministry of Development and Social Inclusion, where the court ruled in favor of the argument citing in lack of motivation. On the other hand, in state contracts, the rule has set out that arbitration is the sole method for resolving disputes. Furthermore, the rule stipulates that in almost all the cases, the costs are to be shared equally between the parties. This is evident in the case of JG Engineers against the Ministry of Culture, where the private party demands compliance with payment for his work and, in addition, insists that the ministry cover the entire arbitration cost since they were the ones who caused the dispute. However, the arbitrator found the payment for the work to be justified, but imposed on the parties to share the cost and expenses of the arbitration equal at 50% each one. To conclude, we emphasize that the national regulation regarding arbitration, the Legislative Decree 1071, are based on the UNCITRAL model law. Furthermore, we underscore the importance of incorporating arbitration clauses into contract, noting that the contract itself can specify the methods of dispute resolution through various types of arbitration. Nowadays in Peru, there are numerous arbitration centers. Some are more expensive than others. Currently, arbitration as a method of conflict resolution is accessible to all. Therefore, Arbitra Peru, as a state institution operating under the Ministry of Justice, established an arbitration clause for low value contracts, such as private lease agreement. Considering that arbitration serves as a means to alleviate the judicial burden, it is also an efficient way to resolve conflict compared to ordinary legal proceedings. In the judicial systems, where a trial can take several years, arbitration ensures the timely fulfillment of deadline as opposed to the judicial systems. So it's a good way to finish this conflicts. Okay, thank you very much. See you next year.